The short video seminar series titled Planning for Your Life and Legacy will cover several important topics including wills, trusts, powers of attorney, and retirement planning. Our speaker is Bill Snyder, a partner at Huddleston Boland's Legacy Planning Group. As an overview, wills are legal documents that control what, to whom, and by whom a person's assets are distributed upon their death. If someone dies without a will, state law will dictate in place of that will. Trusts offer mechanisms for a grantor to separate assets from the control of those assets. Powers of attorney authorize someone to act on your behalf, whether in regards to financial matters or healthcare decisions. And retirement planning is financial planning designed to provide a comfortable income after retirement. It consists primarily of financial management and tax planning. Today's video is on wills.
There are three basic reasons why someone would want to make a will. The first is to direct the disposition of assets upon their death. The second would be to appoint someone to administer their estate upon death. And the third would be to provide for the care of minor children. There's a misperception that only someone who is wealthy or elderly needs to worry about making a will. But these three basic reasons apply to almost everyone in the population. Everyone has certain assets, whether they are cash assets, real property, or even heirlooms that they want to direct to certain people. Everyone cares or should be concerned about who directs the administration of their estate upon death. And everyone who is a young parent should be concerned about the care of their children should they and their spouse pass away without otherwise providing for the care of those children. In order to create a will, the testator must be of the age of majority, which in most states is 18, must be competent, and usually this is interpreted as knowing the objects of his bounty. That is, knowing roughly what assets the testator owns and the identity of those he wishes to pass those assets to. And lastly, the testator must not be under the undue influence of somebody, a family member or a care provider, who may be attempting to sway that person's decision-making if that person is elderly or under the influence of medication. When someone dies without a will, that is called an intestacy. And when someone dies intestate, the state of the person's domicile decides where the assets go and who administers the estate. A judge of competent jurisdiction in that state is going to determine who cares for the minor children of the decedent. For very simple family structures and testamentary plans, this can be an acceptable way to administer the estate. But with blended families, second marriages, children who for a variety of reasons require trusts such as special needs children, these would be inadequate solutions provided under the statutory code. So those are examples of why someone would want to have a will drafted in order to create a more custom solution that's going to address the needs of that family. The decedent's assets are generally grouped into two separate categories, probate and non-probate. Probate assets are those assets which are owned in the name of the decedent himself. Non-probate assets are those assets that pass under a separate contract. For instance, a life insurance policy that has a beneficiary designation, real property that has joint tenancy with right of survivorship, form of title ownership, or a bank account which is jointly owned by two people with right of survivorship. Those are all examples of non-probate property. Those assets are going to pass according to the contract or the beneficiary designation. In the example of a life insurance policy, the life insurance proceeds are going to pass to the named beneficiary and not through the decedent's will. Probate assets, those assets which are held in the decedent's name alone, are going to pass according to the provisions of the will. Most states allow a spouse to elect against a will, that is, to claim a predetermined portion of a testator's estate, dependent on the number of years that person was married to the testator. A typical will contain a number of standard provisions. It will contain a provision that will allow the executor to pay any debts, expenses, or claims that may be filed against the estate. It will have a provision to provide for tangible personal property. Now, tangible personal property is physical objects such as jewelry, watches, gun collections, coin collections, etc. And frequently these will be distributed by specific bequest. Specific bequests are instances where the testator names a specific individual and passes property to that individual. There is a provision in many wills which will allow the testator to make a separate list of tangible personal property and rely upon the executor to make those distributions without having to go change the testator's will, depending on whether or not he's already given away a certain watch to someone or whether that watch doesn't exist at his death. Most wills will also contain a provision for a residuary clause, which is the remainder of the estate. Once the testator has provided for expenses, taxes, and claims, and has provided for specific bequests, the remainder, or it's usually termed the residuary, is provided either to an individual, a trust, or a charitable entity. And finally, a will name specific individual fiduciaries. It will always name an executor to administer the estate, and it will frequently name a trustee to administer any trusts which are created under the will, as well as a guardian to provide for minor children of the testator.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Bowen for more information or to discuss your legal needs.